1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်56ဦးကျင်ခ N1 applicants vs ဦးစိန်ပေါ် respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Revision before ဦးသက်ဖေ Judge ဦးကျင်ခ N1 applicants vs ဦးစိန်ပေါ် respondent State of execution application by the unsuccessful claimant filing a suit under Order 21 Rule 63 Civil Procedure Code Hell, it is elementary principle of law that a seal in execution conveys only the right, title and interest of the judgment debtor to the auction purchaser. SEIN, the unsuccessful claimant in the proceeding under Rule 58 Order 21 of the Civil Procedure Code, who institute a suit under Rule 63, Order 21 is not a judgment debtor or a person claiming under him against whom execution is taken. His right in the attached property will not be affected by the seal. KNRM Chadia vs. Mashuila and others 1940 RLR page 749 Muhammad Haji Wali Muhammad vs. Vetnet Singh and others AIR 1938 Rangoon 21 refer to HS Vodaya vs. the Vijaya Bank Limited AIR 1951 Madras page 321 Distinguished U Mamao Myin for the applicants U Tan Mao for the respondent U Taphe Judge in Civil Regular Suit numbered 104 of 1961 of the Rangoon City Civil Code, the respondent U Sain Bo obtained a decree against U Do for jet 10,000 in the execution of which the respondent attached the house known as 28 Padamya Street, Ledan Quarter, Kamayo, Rangoon. The present applicants U Jinkha and U Han Sein thereupon sought to remove, but without success. They then filed a suit for declaration against the respondent decree holder under Rule 63, Order 21 of the Civil Procedure Code, and as for stay of the execution proceeding that were pending against the judgment debtor Udo, the Lennon Chief Judge, to whom their application was made, refused to stay the execution. Hence, this revision. It is elementary principle of law that a seal in execution conveys only the right, title and interest of the judgment debtor to the auction purchaser. SEIN, the unsuccessful claimant in the proceeding under Rule 58, Order 21 of the Civil Procedure Code, who institutes a suit under Rule 63, Order 21 is not a judgment debtor or a person claiming under him against whom execution is taken. His right in the attached property will not be affected by the seal. In KNRM Chadia vs. Masola and others 1, which follows, the bench decision of Muhammad Haji Wali Muhammad versus Vednath Singh and others too, it was held that a claimant who has filed a declaratory suit with regard to property which has been attached in execution proceeding to which he is not a party cannot obtain a temporary injunction staying the seal, since the amendment of Order 39, Rule 1 of the Civil Procedure Code by the High Court, a court has no power to stay the seal at the instant of a third party. The seal of the property attached in the execution proceeding cannot impel his interest in the property, for only the right, title, and interest of the judgment debtor are conveyed to the purchaser, and if the claimant succeeds in his suit, his own interest cannot be deemed to be disposed of by the seal. The inherent powers of the court cannot be invoked either, for it is not necessary in the ends of justice or to prevent abuse of the process of the court to stay execution when the claimant's rights are not affected by the seal. I am not unmindful of the single judge decisions of H.S. Vodaya versus the Vijaya Bank Limited 3, where it was held that a seal in execution of a decree against the judgment debtor should be stayed under Section 151 of the Civil Procedure Code, pending the disposal of a suit under Order 21, Rule 63 by a claimant to the property. The reason given by the learned judge for adopting this view, which appear on page 322, are that a court of justice, equity, and good conscience must have powers to pass such orders as may be necessary for the ends of justice or to prevent abuse of the process of the court under Section 151 Civil Procedure Code. If, for instance, an attached family heirloom or elephant or gem or painting having a great sentimental value for the claimant is to be sold while his claim suit against a claim order is pending, it may become impossible for the claimant to recover it, and there will be great injustice caused to the claimant if he eventually succeeds in his suit. That will apply also to many other cases. With due respect to the learned judge, if a rare heirloom or gem or painting for which no substitute can be found is involved, there is nothing to prevent the executing court, under its inherent powers, to take appropriate steps in the interest of justice. But in a case where immovable property which cannot be either removed or hidden away is in question, it will not be necessary in the interest of justice or to prevent abuse of the process of the court to invoke the inherent powers to stay the execution when the seal would in no way affect the right, title, and interest of the claimant. In the result, the application for revision fails and is dismissed with costs, advocate fees, Jet 34,